There are statements that would trigger lawsuits almost anywhere else. Accusations, allegations, harsh claims, even deeply damaging assertions. Inside litigation, some of those same statements may receive extraordinary legal protection. Why? Because the legal system has decided that participants in judicial proceedings must be able to speak freely without constant fear of retaliatory lawsuits. That protection is called litigation privilege, and today we examine where that shield begins and where it stops. I am Polymopicus, and this is Polymopicus Legal. Legal concepts explained for non-lawyers, by a non-lawyer for educational commentary, and is not legal advice.
In ordinary life, statements can create liability. Accusations may lead to defamation claims. Threats may create legal exposure. False statements can damage reputations and relationships. But litigation operates differently. The legal system recognizes that lawsuits require people to make allegations, describe misconduct, accuse others of wrongdoing, and communicate openly during the legal process. If every statement made during litigation created immediate fear of another lawsuit, the judicial system could become paralyzed. That is where litigation privilege comes in. Litigation privilege is a legal doctrine that protects certain communications connected to judicial proceedings from becoming the basis for separate civil liability. Litigation privilege protects certain statements made in connection with judicial proceedings. The exact scope varies by jurisdiction, but the doctrine often applies to attorneys, parties, witnesses, judges, and sometimes other participants connected to litigation. The protection commonly covers communications made during litigation, related to litigation, or made in anticipation of litigation. Most often, litigation privilege appears in defamation-related disputes. The basic principle is, participants in legal proceedings must be able to speak candidly without constant fear of retaliatory lawsuits. The doctrine exists because litigation requires open communication. Attorneys must be able to argue claims, describe alleged misconduct, question witnesses, and advocate aggressively within lawful boundaries. Witnesses must be able to testify without fearing automatic civil liability simply because their testimony harms someone's reputation. Courts, therefore, prioritize the functioning of the judicial process over the risk that every disputed statement could generate another lawsuit. Without litigation privilege, lawsuits could multiply endlessly. Participants might self-censor, and the judicial process could become ineffective. Some jurisdictions treat litigation privilege as absolute privilege. That means certain protected statements cannot form the basis for defamation liability, even if the statements were false, harmful, or allegedly malicious. Other protections in law are merely qualified privileges, which may disappear if abuse or malice is proven. But litigation privilege is often broader because courts view uninhibited participation in judicial proceedings as critically important. That does not mean anything goes. It means the legal system strongly protects litigation-related communications within defined boundaries. Litigation privilege is not unlimited. One important limitation is relevance. Generally, the communication must have some connection to the litigation or anticipated litigation. Courts often evaluate whether the statement was related to the dispute, connected to the proceeding, or made as part of legitimate litigation activity. Completely unrelated attacks or communications may fall outside the protection. The doctrine protects litigation participation. Not every statement a litigant makes forever. Litigation privilege may also apply before a lawsuit is formally filed. For example, demand letters, communications between attorneys, settlement discussions, or statements made while seriously contemplating litigation may receive protection in some jurisdictions. Disputes often begin before a complaint is filed. The legal system wants parties to be able to investigate, negotiate, and communicate regarding potential claims without immediate fear of retaliatory lawsuits. But again, the communication generally must relate legitimately to contemplated litigation. This is one of the most misunderstood parts of the doctrine. Litigation privilege is powerful, but it is not a universal shield against all consequences. The doctrine may not protect criminal conduct, sanctions exposure, perjury, discovery abuse, contempt, bar discipline, or court-imposed penalties. A statement may be privileged against a defamation lawsuit while still creating other legal or ethical consequences. That distinction matters enormously. Modern litigation has created new complications. People increasingly live stream disputes, post filings online, narrate litigation publicly, or turn legal conflicts into social media campaigns. This creates confusion about litigation privilege. A statement made inside a judicial proceeding may receive broad protection, but repeating or republishing that statement publicly outside the litigation context may create different legal questions. For example, posting accusations online, monetizing allegations, selectively editing claims for public audiences, or encouraging harassment campaigns may fall outside traditional litigation privilege analysis depending on the circumstances and jurisdiction. People often assume it was in a court filing, therefore I can repeat it anywhere. That is not always safe reasoning. Does litigation privilege mean you can lie freely? No. False statements may still create sanctions, perjury exposure, ethical violations, or credibility damage. Anything connected to a lawsuit is protected. Not necessarily. Courts still examine relevance, context, and connection to litigation. If it was filed in court, then posting it online is automatically protected. Not always. Public republication may create separate issues depending on jurisdiction and context. Litigation privilege makes someone immune from consequences. No. The doctrine mainly protects against certain civil claims arising from litigation communications. It is not blanket immunity. The doctrine reflects a deeper concern. The legal system cannot function if participants fear endless retaliatory litigation for participating in judicial proceedings. Attorneys must be able to advocate, allege wrongdoing, and challenge evidence. Witnesses must be able to testify. Parties must be able to present claims. Courts, therefore, tolerate some risk of harmful statements in order to preserve open participation in litigation. The system relies on cross-examination, evidentiary rules, sanctions, judicial oversight, and adversarial testing to control abuse internally. Litigation privilege reflects an important balance. The law wants to protect reputation, discourage false accusations, and prevent abuse. But it also wants judicial proceedings to function without participants constantly fearing secondary lawsuits. The doctrine attempts to balance those competing interests. Litigation is not ordinary conversation. The legal system allows and sometimes requires people to make serious allegations inside judicial proceedings. Litigation privilege exists to protect that process, but the doctrine is not unlimited immunity. It is a procedural shield designed to preserve open participation in litigation, while leaving other safeguards in place including sanctions, ethics rules, evidentiary standards, and judicial oversight. Because courts cannot function if every disputed statement creates another lawsuit. However, neither can the system function without limits.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.